Hello and welcome to Connected With Latham, where we discuss ideas, trends, and key legal developments shaping the global economy. I'm Ben Potter, a corporate partner in Silicon Valley office. In this episode, we're going to learn about the latest in artificial intelligence. And to do that, we're talking with Bay Area litigation partners Karen Silverman and Michael Rubin, who have been ahead of the curve on AI for quite some time. Welcome both. Karen, Michael, it's probably safe to assume that our listeners get what AI is. So let's start with the current state of AI. What have you both noticed in recent years as the technology has developed?
Thanks, Ben. I think one of the key features that we're seeing is that it is actually out in the marketplace now. I mean, we're moving from an environment where most of this technology was being developed in a kind of lab setting to real distributed implementations. By that, I mean, by clients and companies that aren't necessarily generating the underlying models, but who are starting to deploy the tools that are driven by those models, which may have been developed upstream. So we're just seeing implementations in all kinds of settings, in addition to all sorts of innovation around how this technology can be deployed.
I think that's exactly right. We're seeing it now used in commercial settings routinely. Companies throughout the United States and beyond are using it for things as routine as employment screening, which raises a host of issues we'll talk about. It's being used in insurance contexts, both initial onboarding and underwriting to claims processing, which raises very complex issues. And then all aspects of other types of businesses are now actually employing AI to facilitate not just the sort of routine parts of business like employment and claims processing, but much more fundamental and complex parts of their business where it's the computational power that AI brings across massive data sets that humans really can't do. They can't think about that's now being brought to bear. But one of the things that remains the hallmark and that we're now seeing, and I think is one of the biggest challenges that we're seeing, is that all AI depends on data. It's math, right? But it's always ingesting data. And to get the models to work properly, you have to have very large data sets. And you'd really have to have your head in the sand right now to not realize that the world around how data is being treated is different in 2020 than even that it was 2 years ago, and certainly than it was a few years before that. And that's putting pressure on operationalizing AI right now.
Yeah. And I think that leads to another really sort of interesting point, right? Which is that, first of all, we could spend the entire time here discussing what is AI and what is not AI. But setting that aside for a second, I mean, the general understanding, just from a mechanical perspective, as Michael said, is that it's data plus, fancy math, creating models that yield predictive outcomes, some of which can be better explained than other bits of it. But it's operating in ways that are new and different, and it's sort of the point of it is to exceed the human capacity for computation or pattern detection and things like that. So when you start in a real commercial setting dealing with either the issues that Michael's alluding to about sort of how are the data sets and what is the fuel conditions, that's one set of questions. The other set of questions is what do you do with all the outputs from the models, and how do we assess those in terms of existing standards? What kinds of new standards do we need? How do we distinguish between, crazy outcomes and crazy insightful outcomes, right? And that will differ by not just the technical tool that you're using, but the purpose for which you're using it. So we can speak very broadly about policy and regulations on the one hand, but operationalizing these technologies means that we really need to think very, very specifically about how those policies read on to business practices in pretty bespoke ways and carefully thought through. So it's a different kind of analysis than we've seen done before up to now.
Thanks, Karen. That was interesting to hear what you said about inputs and outputs. Let's expand on that a little bit. Would you help expand on inputs and outputs as they relate to legal considerations our clients face today?
When you think about what's powering AI in a day-to-day basis, and certainly what's powering the development of the models, the machine learning models or the more developed models, it's always data, as I was mentioning earlier. It's always some data set. And if you step back and think about data sets, you have to stop and think, how did they come to be? Where did the data come from? Where did it get collected? Where did it arise? It's certainly possible that it's not personal information. It could be being thrown off in an industrial process. But let's assume for the minute that the more valuable application in a lot of circumstances for a machine learning or an AI model actually is something where the data came originally from some individual. And there's a huge set of data from hundreds of thousands or millions of individuals that are then fed into models to predict the behavior of other people, because this certainly is where a lot of this is going. The legal framework around data collection, around use, is rapidly changing. We saw one of the biggest changes in history come into effect in Europe in May of 2018 with the GDPR. We are in the midst of a sea change here in California right now with the California Consumer Protection Act, which went into effect on January 1st and goes into enforcement on July 1st. And in ways that I think were unpredicted by the folks who put these regimes into place, they have massive impact on what can be done to collect information for these data sets and how these data sets can actually be operationalized into existing models. And so if you are in the process of operationalizing to build a system for machine learning, it is not something that can be left solely to the smartest people in the room, the engineers, who are going to be thinking, how can I use this data to get this result? You need to make sure that you both have the executives in the room to understand what's being done so that they can be aware of the business risk of relying too much on data that's being collected in a way that may be imperiled if there's regulatory change. And, unfortunately, really, you probably need some legal advice to understand really whether what's being done is going to be sustainable. Because the moment that we're in now with GDPR in Europe having been enacted a year and a half ago, with California regime being at the most restrictive in the US, that's a moment in time. These regimes are coming online very rapidly, and they're designed to give users more control and people more control over their information, and that impacts all of the lifeblood of these AI systems and whether or not they're going to be permissible to feed them that data.
Thanks, Michael. That's a lot to consider. Karen, what about outputs? Can you help us think about outputs?
Sure. It's an interesting contrast in a way, because at this point, there is very little regulation out there for how users of tools that are AI-driven can use those tools, how they can incorporate the results from those tools, how they can buy and sell the results of those tools, how they can even contract for the kinds of outcomes they might expect. So in contrast to being a world in which there's sort of known existing regulation, on the output side, we really are in earlier days. There are a variety of initiatives, ongoing right now among regulators to regulate certain aspects of AI production, but those are not particularly operational right now. In contrast to that, though, there are many, many AI policies running around, and many of them very smart and insightful, but very general. And as we were alluding to earlier, and I think as Michael suggested, general policies are instructive, but only to a point when you're considering how to, what sorts of rules to employ internally about a specific tool used on specific data to solve a specific business problem that will impact specific people. And when you think about risk, whether that's legal risk or business continuity risk or reputational risk, it's those business use cases that are going to throw off the hardest questions, right? So it'll be important to have policies and have thought all of that through, but it will also be important to consider how you're going to implement those policies carefully and internally. And much like what Michael was saying on the data side, the value of this thinking and the value of the internal work is pound for pound more impressive when you do it as a function of design and early in the stage than if you try to bolt something on at the end, whether it's the lawyers or anybody else coming in at the end to impose guardrails. Those are never going to work as well as the thinking and the guardrails that are put in place more on the front end. So when we think about all those kinds of risks and all the sorts of things that lawyers and others need to be teaming up to do with and for our clients, we're really thinking about it as a design problem as much as we are a results-oriented problem. I mean, it's very practical, but it's got to be practical within a life cycle of a product that can actually get to market and isn't going to be disallowed or discontinued because something was mishandled on the front end.
That's exactly right. And keying off your observation around the importance of getting the design right from the outset. If you do that, it actually helps solve a separate problem, which is endemic to AI, but it creates a real problem in the legal environment, which is explainability. If AI is working right, and it's real AI, it is doing something that we can't do, that our brains can't achieve, and usually we don't even know how it's doing it. We don't really know how it's getting from A to B, which is part of the magic. And there are lots of thoughts and processes for checking the outcomes and making sure it's doing the right thing. But I actually want to focus on a slightly specific point, which is you have specific data, you have a specific use, and it's being applied for specific people, but sometimes you have a specific problem, and it has a specific bad outcome. And depending on the environment in which it's employed, you then might have a specific regulator, or you have a specific plaintiff coming after the company that's used it. And if you can't explain what happened, you have a problem. And if you're dealing with something where you will not be able to explain what happened because it's part and parcel of what you have to have a strategy for how you're going to solve that. And that strategy has to come from the beginning. You have to be preparing from the get-go for how you're going to be solving that explainability black box problem. And that's not an insoluble problem at all. It's just one that has to be part of the design of the business process around the AI application.
Yeah, I think that's absolutely right. And so when I'm talking to clients about this, I mean, one thing, this technology is overwhelming and people, it's easy to get overwhelmed by it. But it's helpful sometimes to distinguish between when we're talking about the business processes and thinking and forethought that are attendant to how the people are going to behave and how the organization is going to structure itself versus the innate characteristics of the technology that's in question. So I think about, and it's helpful to sort of distinguish between the responsible use of trustworthy technology, right? So if we're talking about responsible use, we're talking about the kinds of business process and accountability and reporting and sort of behavioral stuff that we're used to deploying whenever we're managing groups of people using any kind of tool of any sort. And when we're talking about trustworthy technology, we're talking about what are sort of the innate characteristics of good AI versus, a well-built tool as opposed to a not well-built tool. And that explainability problem, on the one hand, is a very tricky technology problem. On the other hand, it raises all these kinds of responsible use questions, right? And by separating the two, you can start to see how organizations can manage in an otherwise dynamic and kind of uncertain environment, right? Because there's certain guardrails you can put in place in that area that we understand well, which is how we manage each other and our businesses, versus that, and then start to figure out what we need to demand of the technology, which is to, better reveal its processes in certain contexts or other forms of transparency that can help the managers of that technology guide it appropriately and frankly bound it appropriately. I mean, that's the other thing, is this technology does not necessarily know how or when to stop unless it's instructed to stop or bound itself. And so Michael brings up a really, really good point about the innate value of the design function. Because if you're designing an automobile, to use a current example, you don't design it without a braking system. If you're designing a thing that goes, you might design it without a braking system, right? And so you've got to really understand what the purpose of the tool is and how you're going to drive it fundamentally, which is ironic in a world of autonomous mobility. And again, we're talking about AI here, but we're talking about a whole suite of what I like to refer to as frontier technologies, and they include, blockchain and VR, AR, CRISPR, I mean, the stuff that's always on the edge and that's testing us in new ways. One of the really interesting things about this is that these are business strategy tools as much as they are technology tools. And from where I sit, and Mike, I'd be really interested in your perspective on this, in some respect, these are decisions and questions and concepts that boards need to be familiar with, the C-suite generally needs to be familiar with and the legal department needs to be sort of integrated into, because not just because of these risks that we've talked about earlier, but because they'll have legal obligations to be knowledgeable and be able to exercise their duties of oversight and care, but also because small decisions in some of these areas can lead companies strategically in very different directions. And then when we look at what kinds of tools and resources that the boards and executives and legal departments have to understand the tools or their implications, we find that the landscape is pretty bare, right? I think the World Economic Forum has just issued a toolkit for boards to help full of checklists and resources and great definitional materials. And full disclosure, Latham helped put that together with a couple of other partners of the forum. But that was just released, and that's useful because it's a practical guide. It's still very general and needs to be implemented and operationalized, as we've been discussing. But in general, there is not a lot out there yet for executives and non-technical people to rely on. And one of the things that's interesting to me is that this is a big issue within technology companies that are building these tools, and the sorts of issues that they have to think about, but it's also a big issue for everybody else who is now either strategically sort of running towards these tools as for competitive advantage or efficiency reasons. Parts manufacturers for consumer devices, whether or not they're generating AI, are using AI in their manufacturing processes, or they're using AI in their recruiting process, or their auditors are using AI when they're doing their reviews. So everybody needs to get functionally literate in this area, and particularly when you're talking about executives, it's a really interesting time because figuring out what their duties are is one thing, and then figuring out how they're going to discharge their duties is a whole other thing.
Karen, I think that's exactly right. Over the past 20 years, I think there has been, not at every company, but at a lot of companies, a divide between IT and the C-suite. Both a literal divide, the IT being sort of in the proverbial basement and the C-suite being up top, but a cultural divide too. And that has led to, over time, a lot of problems with respect to investment in cybersecurity defenses, investment in real and genuine privacy by design, but we've caught up a little bit in that area. Understanding around those areas have caught up. But with the lack of understanding and the complexity that AI represents, in some respects, I think we're back to maybe repeating the past. And it's important that we not do that. And in some very real respects, AI is very different than what we've seen. It's certainly different than cyber defenses because cyber defense can be business critical. It's usually not the product itself, whereas AI often is. And understanding the business is, of course, one of the charges of the board, but really understanding AI is hard. And I'm not suggesting that the board needs to crack open the algorithm and try to understand the models themselves, but really understanding why choices are being made, how those choices are going to affect the business, how the regulatory environment is going to affect the choices that are being made and may affect optionality and the ability to be nimble or not, or why it's been appropriate to make risk calculations in one direction or another is very important, and the recognition that AI actually implicates all of that.
Yeah, and this is an area, too, where sometimes small adjustments early on can mitigate great risks, right? I mean, so that the bang for the buck here is measurable. And at other times, obviously, more invasive surgery necessary. But there are all sorts of ways to be thinking about these issues and how to create a proper sort of reporting structure and cadence for that reporting structure on these issues, I think is another important piece for all the reasons you just said, right? Because one of the hallmarks of this technology, which we haven't even talked about yet, is that it's designed to change. Right, so that unlike a product that gets put out into the market in a lot number that, as long as that lot number is not tainted, that product sort of remains what it was when it left the factory. This stuff doesn't remain what it was when it left the factory. And so one of the additional responsibilities is some kind of continuous monitoring and it's an assessing of these tools and the outputs of these tools against their original purposes. And how much or little management and the board are involved in that is a decision that needs to be made, and then there needs to be some kind of sort of scaffolding put around that to ensure that it happens the right way. And that's for the purpose, I think, of what, Michael, you've just been describing, which is keeping the board sufficiently engaged and sufficiently knowledgeable that they can, A, discharge their legal responsibilities, but also help anticipate these little changes that'll make big differences.
I think that's all right, but I want to highlight something you said, because I think it's important that we not give a doom and gloom prognosis here. That harken back to something you said earlier on the podcast. Specific data, specific uses, specific application. Because when we're actually in with clients and actually looking at how they're implementing AI or what data they're ingesting, it really is often the case that small tweaks are all that's needed. Sometimes none are needed. But it's often that very small course corrections are all that you need to make something that may have been done with no forethought completely fine. And so it is the kind of thing that once you're aware of it and once you're thinking it through, it's not something that's sort of undoable. Obviously, it's being done everywhere. And so it's something that can work. But it does require making sure your eyes and ears are open to make sure it's going to be functional going forward.
And the other thing I think everybody needs to keep their eyes and ears open for is shifting norms and industry standards. So whereas in time one, it may well be that the use of these technologies is sort of outlier and frontier-y, like we've been talking about. But in time two, it'll become industry standard. And so it would be a dereliction not to be using these technologies. And when those shifts start to happen and the industry standard becomes the deployment of the technology, there's no given corollary that the governance of that technology also becomes industry standard. And so that's just going to put a rush on, I think, companies internally sorting out how to come up with these sort of governance models that are consistent with their larger business standards and values. But that's going to accelerate some of that thinking, Michael, I think both in terms of the specific use cases, particularly like around recruiting, for instance, or auditing, which is going to move faster than perhaps some other areas. Medical diagnostics, I think that's going to move very quickly in some areas, but slowly in other areas. So, for instance, image identification, it is almost the case now where to accomplish a certain diagnosis, you would expect that one of these technologies would be deployed. In other areas, it would still be pretty outlandish to consider that. So I think just being sensitive to how your industry is orienting around the uptake of these tools is important, because then you can also deploy appropriate governance around whether what you're talking about is something standard or something innovative or inventive. So one other just sort of interesting governance question that I think comes up in ways that sometimes people don't expect is that there's a lot of focus right now on how accurate these AI-driven tools are right now at this moment in time. And it is a fair critique that many of these tools are really in early days, and one of the risks that needs to be guarded against is that they are just not functioning right or well, or the data are incomplete, or that they're just not all that they will be eventually. And that is absolutely true. I think the other equally interesting and perhaps more difficult set of questions is how are companies going to actually and in real life deploy these technologies and govern these technologies when they get very, very good, and when those very, very good tools nonetheless yield results or outcomes that are inconsistent with laws or norms or company values, are in conflict with other company objectives, whatever it is. Preparing for a time when we're governing tools that are functioning properly and in the hands they're intended to be in, and not just how are we going to govern them when they go awry or fall into a malactor's hands. So we've got to be looking at all of these different scenarios and thinking ahead, I would argue, in a by design kind of way now, and not wait for that time when the tools get so good that we're now trying to backfill. So when we think about governance, we need to be thinking about it in all of those different scenarios.
There's a real opportunity now where the technology is, believe it or not, still nascent, to build the architecture around it to make sure that we're comfortable with how it's operating and comfortable that we're operating it well.
Well, thanks again, Karen and Michael, for joining us. I know we just scratched the surface on this topic, so hopefully we'll be able to have you back again soon. In the meantime, we're going to drop your contact information in the show notes, so if listeners want to reach out to you about any of the topics you covered, they can locate your contact information there.
Well, thank you for having us. This was great.
Thanks, Ben. This has been great.
Thank you for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of Latham's podcast on lw.com, Apple Podcasts, Google Podcasts, Spotify, or anywhere else you listen to podcasts. If you'd like more information about the topics in this podcast, please email us from links located in the show description. We hope you'll join us again next time.
This podcast is provided as a service of Latham & Watkins, LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins, LLP, and you should not send confidential information to Latham & Watkins, LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things, and you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 885 3rd Avenue, New York, New York, 10022-4834. Phone number 1-212-906-1200.